Hi Mission, welcome to Equity and Trust Partnership. My name is Calvin, a junior associate, and we'll be dealing with two of the cases. So in your first case, you mentioned that you own 50 Bitcoin, a CryptoPunk in your Ledger wallet, and a condominium. You faced a major heart surgery and intended to leave everything for your niece. And you promised your niece the CryptoPunk, the 50 Bitcoin, and the condo. You wrote the Ledger 74-word seed phrase, kept it in the room, and gives her a digital code. You drafted but never executed the gift and emailed your solicitor to prepare a will. So now you recovered and intended to give everything to charity. In your second case, you transferred £4.2 million worth of CryptoPunk and 20 ETH to an influencer, Gearford smart contract after his assurance of safety. But he secretly drains 30% of the assets via a hidden backdoor, and you sued for recovery, but the influencer pleaded clean hands, pointing to your undeclared NFT profits and the use of pseudonym. The maxim of equity winner perfect and imperfect gift is established in the case of Milroy and Lord, which denotes that the donor must have done everything necessary to effect the transfer of property, and equity will not construe a field transfer as a declaration of trust. In such circumstances, the donor is merely a volunteer who has given no consideration, and equity will not assist a volunteer by forcing the completion of the gift or transfer of the property by treating the donor as holding it in trust for the donee. The implication of Mirai and Fry can be seen in the case of Fry, where the court held that Mr. Fry had not done everything necessary until the consent of the Treasury was obtained, despite it being out of Fry's control. So, on one hand, it preserved the element of certainty in law by ensuring that a frustrated intention will not be rescued by the court's interpretation of it as an intention to declare a trust, or otherwise the requirement of intention will be rendered too vague, which would moribund and available to perfect any imperfect gift. On the other hand, the rule illustrated objectivity and harshness, where it disregards the burden imposed onto a donor in effecting a gift, and donors are to take on additional burden to do everything necessary to establish the gift. The solely objective approach has, however, led to the departure of the rule to encapsulate more subjective elements to it. In rerolls, it was held that once the donor has done all actions necessary for the donor to effect a valid transfer, equity will deem the transfer effective, irrespective of the donor being a volunteer or certain formalities remain unfulfilled, as it would be unconscionable for the donor to renege his intention to transfer the gift. A more interventionist approach is taken in T. Chofram International SM and Patarani, where the Privy Council departed from Mirai by establishing the unconscionability test, where equity will perfect any imperfect gift if it would be unconscionable for the donor to resell his intention. The test was nevertheless extended beyond its former boundaries in Pennington and Wynne, where the court held that the underpinning test was unconscionability, and equity would not strive officiously to defeat a gift. The judgment has established a broader judicial approach whereby the court will perfect an imperfect gift if it would be unconscionable for the donor to change his mind, despite the donor having neither effected a declaration of trust nor done everything necessary for her to effect the transfer. So the test is subject to various academic criticisms for its unjustified departure from the maxim. Pennington's judgment is too vague and has caused erosion to the maxim. The judgment failed to deliver a definitive scope of unconscionability, leaving it as an open-ended tool to perfect gifts. Let's argue that in Pennington's case, Arden Law Justice relied on proprietary estoppel as an alternative basis for her decision, whereas emphasis was put on Downey's detriment reliance and broader notion of unconscionability, rendering it too difficult to reconcile with the traditional rigorous approach, which could open floodgate effect on equity. The recent application of the maxim can be seen in two cases in which both has taken a different approach in applying Pennington. In Abdul Rauf and Abdul Rahman, the court, in seeking to mitigate the vagueness and unpredictability of the maxim, incorporated detrimental reliance as a requirement based on Clark Law Justice judgment in Pennington, where the donor accepted the position of a director before he could hold the shares. In effect, Abdul Rauf flips Pennington into a donor-centered principle, which is doctrinally unsound and is outdated, where under Section 291 of the Companies Act 1959, the donor is to vacate the position if he failed to hold the minimum numbers of shares. However, such judgment is neutralized under doctrine of separate legal entity under Section 192 Sub 1 of the Malaysian Companies Act 2016 and mandatory ordinary resolution for the removal of director under Section 206 Sub 1 Sub A of the Malaysian Companies Act 2016 and Section 168 of the UK's Companies Act 2006, paving the way for the reversion to the original rule in Tan Sri Dato Kam Woon Wah and Dato Sri Andrew Kam Tai Yao, where the court ruled that it suffices that the execution of the share transfer form creates a trust, entitling the donor to compel the donor to procure registration. It was suggested in Equity, Perfecting an Imperfect Gift of Shares, a comparative study on the rulings of Malaysian Federal Court and English Common Law, that a more balanced approach can be achieved based on Clark Law Justice judgment, where it occurs the donor executes a shares transfer form and intends that moment to make an immediate and unconditional gift or transfer. The donor is treated as having done everything necessary within his or her own power to divest the equitable interest, and the donor becomes the full beneficial owner, while the donor holds that bare legal title of constructive trust and can be compelled to procure registration. The objectified test examines the needs to examine whether the parameter of the facts falls within the scope of Pennington, creating greater consistency in future cases, thus provides judicial certainty and uniformity. Under the current legal framework, the principle of equity will not perfect and imperfect gift operates narrowly, as it is subjected to numerous exceptions. Under the doctrine of donatio mortis causa, a gift is effective if the gift is made in contemplation of the donor's death. It is intended to be revocable up until the donor's death, and there must be actual delivery to the donee of the dominion over the subject matter. Secondly, a gift may be perfected under the strong and bird rule, where the subsequent appointment of the donee to be the donor's executors when the donor has the intention to make an outright gift, and that intention survives until the donor's death. Alternatively, a gift can be enforced by a proprietary estoppel when the donee has acted to his detriment, relying to the donor's assurance which gave rise to his expectation to be entitled of the gift. And lastly, equity will perfect a gift when there is a fortuitous vesting of legal title. And rarely, the donor promised to transfer the money obtained from the first trust to be settled in the second trust, but she later refused. So the court upheld the second trust on grounds that she had remaining interest at the time of the promise to settle property, which binds her to execute the transfer. So, in your case, the court will not enforce the transfer of trust property on grounds that there was no effective transfer and neither have sufficiently executed the transfer or validly declare yourself as a trustee. DMC is not applicable despite contemplation of impending death was present. There was no actual delivery or dominion. Secondly, strong and bird is not applicable as your niece was not appointed as an executor or administrator of the estate, and proprietary estoppel will also not validate the trust due to the absence of detrimental reliance. And last but not least, there was no prior trust or covenant under your niece's remaining interest, which would render the trust valid. Thus, the maxim will be enforced in full rigor. The origin of the maxim, "He who comes to equity must come with clean hands," needs to trace back to the 18th century, where the phrase was first regarded as equivalent as the maxim, "He who seeks equity must do equity" in Fitzroy and Guillim, a principle which is now regarded as distinct, being concerned with the claimant's future rather than past conduct. However, the first case that distinctly established the maxim was Derling and Earl in Chelsea, the case concerning the claimants who defaulted and sought to obtain a contribution for other sureties. The Earl ruled that he could not claim the shares due to his misconduct, including encouraging his brother to misuse government fund to gamble. The court, in considering the circumstances under which specific performance could be ordered, ruled that a man must come into a court of equity with clean hands, but it does not refer to a general depravity. Such misconduct must have immediate and necessary relation to the equity sued for, and it must be a depravity in both legal and moral sense. The maxim, "He who comes to equity must come with clean hands," denotes that an individual who has committed wrongful actions cannot rightfully seek justice from a court, given their lack of equitable behavior. It provides a judicial defense in the event where an equitable remedy is sought by a claimant who has engaged in an illegal or unethical act in the same subject matter. The clean hands doctrine set out the foundation principle for the grant of equitable remedies, where it bars any claim by any claimant who has acted unfairly against the dealing party in respect of the matter sued upon. For instance, in Tinsley and Milligan, the defendant who depicted into the contribution of the purchase price of the house claimed possession after finding out the conveyance was made into the claimant's sole name to enable the defendant to make fraudulent claims for the housing benefit. On grounds that the claimant could not make her claim without admitting her own illegality, the court refused to enforce a trust in the claimant's favor. Comparably, in Argue and Argue, the Duchess was entitled to an injunction prohibiting the Duke from publishing an account of her marriage, despite her immoral approach regarding it. The court places emphasis on the character of the party seeking relief, where the court will reject any recognition or relief pertaining to the subject matter in question unless the suitor demonstrates conduct which is consistently fair, equitable, and just. As rule enduring, the clean hands defense applies when two cumulative elements are satisfied. Firstly, the claimant's past misconduct, though not necessarily illegal, must be so improper that it would be unconscionable for the court to grant the equitable remedy sought. In Fogg and Gray, which indirectly applies the maxim, the court refers specific performance on grounds that the claimant had knowingly purchased the vases at a price far below their true value. Despite Mr. Fogg having not done anything he was legally bound not to do, the court, recognizing the clean hands doctrine, refused specific performance in line with established authority and the justice of the case. Apart, the court may refuse equitable relief on grounds of applicant's iniquity. In Glynn and Western Feature Film Company, the court denied an injunction against the distribution of a film which is a spoof version of the claimant's novel on grounds that the novel was a glittering record of adulterous sensuality masquerading as superior virtue, which merits not equitable protection. In Pitt and Holt, Supreme Court indicated equitable jurisdiction may refuse to rescind a voluntary disposition for mistake if it forms part of highly artificial tax avoidance. As such, schemes are considered social evil that unfairly shifts the tax burden onto the others who do not adopt such burden. In addition, the claimant's misconduct must not merely be an act of unfairness, but also bears an immediate and necessary relation to the equity suit for. In Royal Bank of Scotland and Highland Financial Partners LP, the claimant sought anti-suit injunction against the defendant who brought an action against the claimant who obtained the English summary judgment against UMM using a sham auction of the underlying loans and false testimony from its witness. The Court of Appeal ruled that the claimant's dishonesty was causative of the judgment, and but for the fraudulent misstatement and concealment, they would not have obtained the summary. Therefore, it would be unjust to allow claimants to retain the benefit of an inequitable conduct. In The Future of Clean Hands by Nicholas McBride, it was opined that the maxim shall be abolished. As true intensely, the clean hands doctrine was consciously subordinated to the common law defense of illegality. When the defense of illegality is not applicable, clean hands doctrine shall not be applicable either, as the independent operation of both defenses would cause the law to be incoherent and unprincipled if the claimant was allowed claim under common law illegality barred from clean hands. It was opined that the law shall speak in one voice, and the prevailing precedents of illegality shall take priority over clean hands. Similarly, in Patel and Misra, it was ruled that the clean hands doctrine shall be exclusively confined to cases of actual unlawful conduct, where the defense of clean hands shall not be applicable merely on grounds of claimant's sharp practice, trickery, or immorality. The independent application of the doctrine would lead to intolerable inconsistency and offending the rule of law by allowing the court to impose subjective moralization. Therefore, the clean hands doctrine turns out to be supererogatory and has no place in the modern system of private law. The maxim has nevertheless positively contributed to the development of equity as a second-order safety valve to safeguard against opportunism across jurisdiction and areas of law. Under trust law, the clean hands doctrine is reiterated under the law of probate, which bars any equitable claims against unclean hands. The general rule in establishing a trust is that there must be a certainty of intention established by the use of imperative words, which indicates the settler's intention that certain property is to be held on trust of a beneficiary. However, the court will not enforce a trust which is in truth a sham. In Midland Bank and Riad, a trust purported to vest the interests of the matrimonial home to the settler's wife and daughters was declared invalid on grounds that the settler's true intention is to put his property beyond his creditor's reach, but not to endow them with an interest with the matrimonial home. Moreover, in Regal Corp Exchange and Hunter and Moss, which are two significant landmark cases which underpin the requirement of segregation in establishing the certainty of subject matter. In Regal Corp, the court rejected the claims of trust on grounds of uncertainty of subject matter, as the category of fungible products was not segregated from its bulk, rendering it unascertainable. However, in Hunter and Moss, the employer promised to hold 5% of shares out of his 950 shares for the employee, but later claimed that the promised part of shares was never ascertained, giving rise to uncertainty of subject matter. The trust was nevertheless found valid despite the shares not being segregated from its bulk. The precise and coherent reconciliation of Regal Corp and Hunter and Moss lies in the operation of the clean hands maxim, as the employee did not come to equity with clean hands as he was attempting to weaponize the certainty requirement to retain for himself the property he had already promised away. The maxim took place by relaxing the requirement for segregation and barred the employer from misusing equity from benefiting from its own wrongdoing. In Go Corp, no party was seeking to profit from its own breach, and the issue was mainly focused on the allocation of trust property among unsecured creditors, which has no basis for the operation of clean hands maxim and binds the court to enforce the segregation requirement with full rigor. Under contract law, in the case of Ling Xuju and Ong Ko Ho, clean hands doctrine was invoked as one of the striking aspects in the refusal of the grant of restitution to the respondent and who is an unlicensed moneylender. On the fact, the respondent who was sued for breach of defaulting on the payment obligation owed to the appellant by a counterclaim for restitution on grounds of failure of consideration. The court rejected respondent's claim on grounds of appellant's partial performance and struck down his counterclaim on grounds of clean hand. As the respondent who was declared an unlicensed moneylender under the Moneylenders Act 1951, an act enacted for public protection and moral policy, which defeat would undermine the purpose of the statute and reward unlawful conduct. Restitution, being a discretionary equitable relief, cannot be used to circumvent statutory prohibition or public policy. Applying the maxim to your case, the defense of clean hands will be rejected on grounds that your tax evasion is not an immediate and necessary relation to the subject matter of the case. By contrast, the influencer's hands are unclean, as his misconduct are directly and causatively linked to the transaction that he induced the transfer by false assurance and exploited his own code to steal the assets, on grounds that clean hands doctrine is not a balancing exercise between parties' overall morality, but focused on the claimant's conduct relevant to the relief sought. Your collateral misconduct will not bar your claim, but excludes the influencers from recognizing the doctrine to retain benefit from his wrongdoing. In conclusion, the meta role of equity is to combine formalities and contextualism to address complex situations to deliver general and yet exploitation-resistant judgment. Far from being vague aphorisms, it shall be noted that the maxims are the meta of the meta law, which provides a broad general view of equity as a working system of jurisprudence, which shall be understood to be generalities, never meant for direct literal application. Under the modern legal landscape, equity is becoming increasingly homogeneous, triggerless, and second tiers, stemming from its aspiration to generality using defined triggers based on deception, bad faith, and unconscionability to ultimately apply to a more contextual, morally informed analysis that counters opportunism. Far from being obsolete, equitable maxims remain the conscience of law. They continue to access significance in modern jurisprudence, ensuring rigorous enforcement of legal rules never become an instrument of injustice, and fairness and justice always retain the latest word. That's all from me. Thank you.